of each conclusion, I have brought it back to the conclusions and disposition. So that on issue 1, I find that no qualitative disqualifying attribute in appointment and dismissal of IEBC election officials was demonstrated. On issue 2, again, I have plucked the conclusion I reached under that issue and brought it forward. It was demonstrated by evidence that there was a physical register, voters register available at every polling station, that it had a QR code, that the KIMS kit had a soft copy replica of that register. No evidence was availed that any voter was disenfranchised, since the physical registers were present and were also replicated in the KIMS kit. Then I point out the jurisprudence on the use of the physical register is essentially what is carried in the UDA case, that such register is only to be used in instances where biometric or alphanumeric identification fails. The UDA case, I may say, does not entirely deal with Section 72, Regulation 72. It doesn't entirely with regard to assisted voters. There was no evidence of such failure of identification. The prevailing jurisprudence on the use of registers is the UDA case, is that such register is only to be used in instances where biometric or alphanumeric identification fails. There was no evidence of such failure of identification. Had there been a failure of biometric and alphanumeric identification, followed by failure by IEBC to deploy the physical register, a case of voter disenfranchisement would have been readily made out. On issue 3, whether there was unlawful third-party interference, on this I came to the conclusion that it was not proved that admitted interference with the register was either widespread, systemic, or intended. In substance, therefore, there was no proof that of the fact that the sole instance of interference that we saw in the case of Collins affected the will of the people. It was also held that in the case of one individual, where the register was shown to have been unlawfully altered, the officer involved may have committed a criminal offense. On issue 4, the same summary that I take the same summary or conclusion, and this is where I said Kaungu theoretically suffered a turnout decrease of about 8% of 51 voters as against the constituency average. But I found overall the failure did not affect the outcome in terms of Section 81 of the Elections Act. Section 82, sorry, of the Elections Act. On issue 5, whether there was bribery treating, maybe I just read all of them, if you don't mind. Let me just read all of them so that I don't give an impression. On issue 5, whether there was bribery, treating, and undue influence in violation of the Election Offences Act and the Constitution, there was uncontroverted evidence of bribery involving 2 witnesses. As an election court, this court can make a determination only on whether the election malpractice, whether an electoral malpractice of a criminal nature may have occurred in terms of Section 87 of the Election Act, but not on whether the offence of bribery was committed. I do find that an electoral malpractice of bribery may have occurred. As to whether the electoral malpractice of bribery and voter influence so found results in the nullification of the election, the evidence does not show that the scope and prevalence of the malpractice substantially affected the result of the election in terms of Section 83 of the Elections Act. On issue 6, whether there was broken chain of custody, unlawful handling of election materials, and violation of procedure on close of polling, the totality of the evidence availed disclosed that out of 134 polling stations, there was broken chain of custody, possible unlawful handling of voting material, but no violation of poll closing procedure at Gitiburi 1 and 2, except with regard to the time. For Kaungu, there was evidence of violence, but no evidence of broken chain of custody. unlawful handling or violation of poll station closing procedure. Consequently, there is no basis for a finding that the irregularities or non-compliance were substantial and affected the election outcome in terms of Section 83(1) of the Elections Act. Had it been demonstrated that the sort of violence shown at Kaungu was pervasive or widespread, a positive case would have been made out to conclude that the violence affected the overall quality of the election and had a significant impact on the result. Issue 7, on whether there was use of state resources, state security offices to influence the voters. It was incumbent on the petitioner, in order to prove issue 7, to provide at least the minimum information or proof, the names, some of which were provided, their formal designations, the offices held, and particulars and nature of the alleged abuses of such offices, provisions of the law breached, and the overall effect of such abuses upon the electorate and the election outcome. The petitioner failed to provide these through the evidence adduced. Accordingly, the court is unable to find in his favor on this issue. On issue number 8, the same, the court was unable to find in favor of the petitioner, the same on even the assisted voters. Because with the assisted voters, what I have done is that I have said I take seriously the caution by the superior courts concerning unpleaded evidence gathered through scrutiny. The outright determination, the overall determination, for all the foregoing reasons, the court finds that the petition was not proved to the required standard, and it is hereby dismissed with costs. The costs are as follows. The parties made submissions on costs, generally to the effect that costs follow the event. The first to third respondents' counsel went into some fair detail in indicating the depth of the case, the number of attendances, preparatory time, complexity, and so on. The first to the third respondents and the fourth respondents both indicated that costs should be at Kenya shillings 5 million. The petitioner only submitted during highlighting. So having considered the nature of the case and the input of the parties and noting the fourth respondent did not testify or avail witnesses, I hereby cap party and party costs at Kenya shillings 4 million. The first to third respondents shall be entitled to 70% thereof, and the fourth respondent to 30% thereof. I have prepared a report of the court on electoral malpractices under Section 87 of the Elections Act, which is as follows. The court finds that the following malpractices of a criminal nature may have been committed. And directs that the same be transmitted to the DPP. A. Admitted alteration of register without authority, contrary to Section 6(1) of the Election Offences Act. B. Double assistance of voters, that is allowing 6 persons to assist more than one voter, each contrary to Regulation 72(5)(c) of the regulations. C. Failure to record in the polling station register against the name of the voter the fact that the voter was assisted, contrary to Regulation 72(6). I will make recommendations separately. I will not, because there's no point of putting the recommendations in the judgment, but I'll make recommendations separately, particularly for IEBC's notice, subsequent to this judgment, because I think it is important. Certificate of court as to validity of the election under Section 86 of the Elections Act. Having concluded the hearing of the election petition, I certify that the petition was dismissed and the fourth respondent remains the duly elected member of parliament for Mbeere North constituency. This information is to be transmitted to the Speaker of the National Assembly. Orders accordingly.
Yeah, my lord, we are most obliged by the decision of the court. We have sat and listened to it. We appreciate where the court is coming from, but we, however, would wish to make an appeal in regard to some of the issues the court has dealt with. And therefore, my lord, we are making an application for expedited provision of typed proceedings, the judgment of the court, and the decree accruing therefrom. Your Lordship, the reason for the appeal is, my lord, that this might be the only time the certain issues will be clarified by the Court of Appeal, most importantly, the question of the alteration of the voters register. And my lord, since I am not making an appeal before you, would wish to make the Court of Appeal pronounce itself. Number two, your Lordship, on the question of the scrutiny that was dealt with by the Deputy Registrar. My lord, we have listened to you and the judgment, and we note that the judgment itself does not capture the entire report as reported by the Deputy Registrar, and most importantly, in respect to ballot box number 35 and the 212 votes that were cast in foil. We have not heard you pronounce yourself on that, your Lordship. Would we therefore wish to make an appeal? And then, my lord, I don't know how that will square out, because it has not been captioned in your judgment. Because, my lord, when you ordered,
it should be easy enough, because the proceedings of the registrar will be part of the proceedings of the
yes,
court.
my lord.
So you just annex them and say that the lower court failed to deal with an issue.
My lord, we will be obliged. We are otherwise happy that the court has made its decision. We'll try our luck in the Court of Appeal. We are most obliged.
Fortunately, the judgment is typed already.
Yes, my lord.
The proceedings are typed, so it should be fairly easy to get the record fairly quickly.
We will get it, my lord.
Yes,
Yeah, my lord, GACHAGUA'S, and I thank you for that judgment. My lord, I just have one request, and as we review the judgment, so that then we can see what we make of it in terms of what is the next step. We just like to make an application for stay of execution on the issue of costs, because we know we have money in court. Yeah, so that, my lord, the issue of
Costs may be given about 30 days for us to review the judgment before the money is released, if such an order is sought, so that then we can make the appropriate application, if any, upon taking instructions. So that, my lord, if, as Mr. Ndegwajiro mentioned, if there is any need for review or clarification from the court, then we can have that period to consider all those options. That's all, my lord.
yeah, I'm being informed that I seek 45 days, kindly, my lord. 45 days, my lord. That's all, my lord. Thank you.
he's asking for 45.
Yes, I hear you, my lord.
Yes.
We would be opposing the request for stay, my lord. There is no indication upon which such a stay would be predicated, my lord. No appeal has been filed as yet. Even the costs have not even been ascertained.